Well, welcome everybody to our Start Smart on intellectual property law. Kit hopefully will be joining us soon, but in the meantime, you've got to put up with me. I've been doing this with David and our friends from KnowHow Gates for a little over 10 years now. And this is always one of the most anticipated sessions because so many of the startups we work with have IP questions that they need to really deal with very early in the process. So tonight, in addition to David, our regular MC, we've got Loren Murray and George Dickos. I also see we have Carrie Zhu, another KnowHow Gates recent alum who was one of my students, so that's always exciting.
Hi, Stephanie.
Hey, Carrie. So I think, if anyone, I know Kit always starts out by asking people if there's any needs that you might have that you would like to broadcast out to the people online. Any startups looking for help, any other students looking for startups, we're happy to help you get the word out.
Hello, I'd like to go first.
Sure.
My name is Arjun. I'm a grad student at Pitt. I came up with an idea in my medical products innovation class, but I didn't use any of the class resources to kind of start prototyping. I just used the reading to kind of spark my imagination. But anyway, the point is, I know that Pitt likes to take 40% of a company that's developed using their resources. So how do I position myself defensively to avoid an awkward conversation, or at least assert that this is my idea, my thing?
Well, we'll get into the policies for Pitt and CMU in a little bit. You're a student?
Yeah, a grad student at Pitt.
You should be safe, so long as you have not used, university funding to do what you're doing.
Okay.
But I'll leave it to the experts to go into more detail.
Cool.
All right. Anyone else? All right, David, I'm going to hand it off to you.
All righty. Well, good evening and welcome to the Start Smart. As Stephanie said, my name is David Lehman and I'm a partner with KnowHow Gates. Been there longer than I'll ever admit, and longer than they wanted me. And I had the benefit of leading the discussion regarding IP, even though I'm not an IP lawyer. So that means I get to pontificate about things I don't know about. But I've represented lots of startups and things like that, so I have a keen interest in it. But I did bring along friends who can spell the word patent. So let me maybe let my colleagues and Reid introduce themselves to you so you can see who our panelists are. So George, you want to go first?
Sure, thanks, David. I have the auspicious honor of starting at KnowHow about the same time you did, so that's a tough indictment.
In the office next to me.
Yeah. Very, very close to in time. I am an IP lawyer. I started off kind of in a traditional patent law context, but now do mostly transactional work, counseling, trademark work, and I oversee patent prosecution. So I have a kind of a broad spectrum IP practice.
Thanks, George. Loren?
Hello, I'm Loren Murray. I am also a partner in the Pittsburgh IP group. I predominantly focus on patent procurement. My background is mechanical engineering, so I work with a whole range of clients from startups to much larger entities with innovation in the mechanical and electromechanical field. So,
thank you.
Nice to be here.
Thanks, Loren. Reid?
Hey everybody, I'm Reid McManigle. I work in the Technology Transfer Office at Carnegie Mellon. My role there is to help faculty and PhD students as they try to create startup companies and grow them around their research results. I've worked at the Tech Transfer Office at CMU for 16 years. And earlier I was in Pitt's Tech Transfer Office for about 10 years. I've also worked in several different economic development organizations in Pittsburgh. So I have many years of experience of the process of protecting IP and trying to move it out of university through licensing and startup formation.
Thanks, Reid. So we thought, number one, you should feel free to ask questions along the way. This is a informal presentation. It's intended to be sort of more of a dialogue. And so there's, for the most part, with one exception, there's really not much of a PowerPoint presentation. And we'll be talking through the issues, oriented mostly toward, again, startup companies and growth companies and technology-oriented growth companies is sort of the emphasis. And I think of the world of IP and startups sort of with three questions in mind. Other people have heard me say this before, but I really think of three questions. One is, do you own the intellectual property? Two is, are you infringing somebody else's intellectual property? And third is, what are you doing to protect that intellectual property? And we're going to deal with all three of those, but I'd like to actually do it in the inverse order and maybe talk about sort of protecting your intellectual property and what your intellectual property. It's important to, in my view, is to have we can call it a roadmap, you can call it an approach, you can call it, but you ought to have some approach going into it as to how you're going to protect your intellectual property. And as you probably know, there's a variety of ways to do it, whether it be patents, copyright, trade secret, or trademark and service marks as well. And as toward the end of the session, we'll talk about specific ways to search, and Loren will walk us through some of those, but we're going to get to that in a little bit. But maybe I can ask, we're going to take these one at a time and get some basics out in the first instance, and talk a little bit about patents. And maybe I can ask again the experts. Maybe talk for a moment about the different kinds of patents, because there are different kinds of patents, right? George, maybe you want to spend a minute on that?
Sure. A typical patent, when we think of patents, most people think of a utility patent as opposed to a design patent. A design patent protects the outward appearance of something, the outward characteristics and features, but a utility patent protects the claimed invention. It can protect articles of manufacture, machines, methods of doing things, chemical compositions, a variety of things, what can be protected by a patent. It's really important, I think, to understand what a patent is. A patent doesn't give you the right to practice the technology that it covers in the claims of a patent. A patent is basically a contract between the inventor and the government that says, if you disclose your invention in a proper patent application form, and it's new and non-obvious and useful, and you claim it properly, you describe the metes and bounds of the invention properly, we'll give you, in essence, a monopoly on that for a certain length of time. The thought being that then society can build upon your invention and advanced technology. And it's worked out pretty well that way. But it is still possible to get a patent on something that infringes someone else's patent. So that's why I say it doesn't give you the right necessarily to practice your invention, but it gives you the right to stop others from practicing the claimed invention.
And generally, what does one need to, what are the requirements to get a patent?
As I mentioned quickly, the technology, you've got to put together a proper patent application that has drawings and a description of the invention, and then these claims. The claims describe the metes and bounds of the invention. And this is really what's important. People think, oh, my patent said X. Well, that's really not what matters. What matters is what's in the claims. Think of it as like a deed to real property, where very specifically, the metes and bounds of the real property are described in the deed to your property. So at this point, you go so many feet that way, that direction, and you circumscribe the boundaries. The wording of the patent claims does the same thing. So if people do things that come within the four corners of that claim, they literally infringe the patent. And if they exclude an element or they make a very significant change, they don't infringe.
And so in order to get a patent, I mean, for example, novelty.
Oh,
I mean, what-
right, yeah. That I'm talking about the application process itself. You got to put this application together. But as Dave mentioned, you have to, the technology has to be, the claimed invention has to be novel and not obvious and useful, but anything we're talking about here today, I'm sure we can assume is going to be useful. Novelty means that it hasn't been done exactly in the prior art. And exactly means exactly. And what's in the prior art, prior patents, publications, public uses, stuff that's been on sale, stuff that's been publicly disclosed or publicly used, that's in the prior art. And we compare your novelty to what's been done before. Now, you can imagine non-obviousness is an amorphous concept. It means what the legal standard is in the Patent Act. Would your invention be claimed? Would your invention, the claimed invention, be obvious to one skilled in the art at the time the invention was made? So you can see how it gets a little bit fuzzier there. If you're using something for its intended purpose, that would be obvious. An obvious substitution of one element for a known element would also be obvious. But what you have to look at is the combination of the claim elements, and when they, taken as a whole, be obvious to one skilled in the art. One way that we often can show non-obviousness is some kind of teaching in the art away from the claimed combination. If there's a reason on the face of the asserted prior art that the examiner is putting together against making the combination, then it would be non-obvious. So these are tough judgment calls, and how patent lawyers make their living is in dealing with these questions. But our general philosophy is, if the invention is not, if the invention is novel, in other words, it's not identically disclosed in the prior art, we like to give the inventors a chance to get a patent. We'll file the application for them, make the arguments, and do the best we can to show non-obviousness if and when it is asserted by the examiner.
Some people file provisional patents, right? Applications. And
Yes.
I've had clients who did it in part for cost reasons, but that's not the only reason. So why do people file provisional patent? What is it and what does it mean?
It's a great question. Provisional patent application is in essence kind of a stakeholder. You're putting your flag on the moon that you're entitled to this entitled patent on this technology. People think that once you file a provisional patent application, you're golden. The process is over. You're going to be a billionaire. Provisional patents is really important to recognize. Provisional patent applications can never mature into a patent. Okay, they can never mature into a patent because they're just kind of a line of demarcation that you're disclosing this technology as of a certain date. The key is within a year of the filing date of provisional patent application, you have to file a non-provisional patent application, which is a real patent application for a utility patent that meets all the requirements of the USPTO. Again, disclosure of drawings and description and the claims. All those requirements have to be made. Now, as Dave mentions, sometimes people file provisional patent applications, oftentimes for cost reasons, oftentimes for time reasons. If let's just say a professor from one or two unnamed universities is going to a conference tomorrow, you want to file, and they think they might have something, you want to file a non-provisional application with the disclosure as best you can. At least you're getting that stakeholder in the ground. You can file the utility non-provisional application within a year. But people get a false sense of security, as you might take from my enthusiasm here. People don't really remember that the disclosure requirements for provisional patent applications are the same as for non-provisional patent applications. So you can't file a provisional application, provisional application with just, one sheet of information and then elaborate on it in the non-provisional application and be entitled to the original filing date of the provisional for everything in the non-provisional. That which is disclosed in the provisional, you're entitled to that filing date. But stuff that isn't disclosed in that isn't entitled to that filing date for priority purposes. So prior art could theoretically come in that intervening period there. So it's really important to recognize that at least the disclosure requirements of provisional patent applications are just as stringent as the non-provisionals. Now, one way there can be cost savings would be not to file claims in the provisional application. You don't have to file claims there. So long as the disclosure is really robust, you're okay with the provisional, and then you can follow up with the non-provisional. Frankly, our practice is, if possible, we like to do the full application up front, if time and finances permit that. But if not,
yep. I mean, sometimes it is a strategy. It's an alternative strategy.
it is a strategy. It is less expensive to go that way, but you really need to have a good disclosure in the provisional if you're going to go that way.
And the
George,
non. Good. I'm sorry.
I was just going to ask George, do you have a sense of what % of provisional patents actually turn into real patents? What % are rejected by the patent office, and what % actually turn into real patents?
Well, provisional applications aren't examined.
Non-provisional. Pardon?
Provisionals are not examined.
Right. Well,
that's
my point. It's not a guarantee. It's a place in the ground. You're planting a flag, but some are eventually refiled as non-provisional and get accepted, and some are rejected. Do we have any sense of what that percentage is?
We've phrased the question a little bit. I guess first question is, how many provisions are actually filed, provisionals are filed as non-provisionals ultimately? I don't know a number. I would say pretty high. In our experience, it's pretty high. Would you agree with that, Loren?
It's pretty uncommon that we don't convert the provisional and file a non-provisional. So yes, most of them are converted then to a non-provisional. Then I think the question is do those applications ultimately mature into a patent? And I don't know the difference between those filed as provisionals initially and those filed as non-provisionals. You can have claims in your patent that are supported by the provisional disclosure and others that are supported by the non-provisional disclosure. With, if effectively they'd have a different effective filing date and different prior art applied on a claim by claim basis. So it can get pretty complicated to try to figure out which of these claims were originally supported by the provisional that ultimately matured into a patent.
But let's expand the question as to the percentage of patents that are patent applications more generally mature into issued patents. And if I'm following Don's line of questioning, it's okay, you're going to spend some money on this. What's the probability of getting an issued patent and a real asset out of this application when you spend the money? And I would have thought that's a function of the amount of work you go into it in the first place, figuring out the extent to which there's underlying, have you done a search? Have you looked to see what else is out there if it's novel? I mean, it's a function of how much homework you do going into it as to whether or not the probability of it being issued. But having just guessed on that answer, let me let the experts answer the question. I think, you are asking people they have limited resources in startups. You're going to spend, we're going to talk about the cost, but call it, thousands of dollars on a patent application. And we can minimize a little bit and sort of stage it with a provisional, but it's thousands of dollars, limited resources. And what's the probability of getting an issued patent at the end of the day and a real asset?
Well, it's funny that answer's changed over time, Dave. It used to be many years ago, we searched a lot of stuff before filing. Now, because of cost considerations, rarely does that happen. So you're kind of going in without a real good sense of the prior art, just for cost reasons, which is very understandable. But to Loren's point, we really want to go in with a good disclosure, because I don't know the exact number, but I would say for cases that we file with a good disclosure, I don't know, 80–90% of the time we do get a patent.
Let me ask.
Oh, if
Yeah.
I can answer from a CMU perspective.
Yeah, that was about to
Um,
bump it to you. Cool.
We are sort of free spending sailors about filing provisional patent applications, because often like the professors are coming to us with very little time, and we hurry up and file a cover sheet provisional to meet a filing deadline. But we tell them then, we're going to work with you over the next year and figure out if there's really a market, does this technology really have some promise, et cetera, before we decide whether or not to file the non-provisional application. So we file many, many more provisionals than we actually convert to a full patent application. But similar to the experience we're hearing from K&L Gates, once we do that full application, the chances are pretty high that we've done our homework and we're going to have a patent end up getting issued.
Cool. And a cost, just so we're on the same page, just so people know, what's an average cost for a patent application?
Loren, you want to field that one?
Sure. Well, of course, the answer is it depends on the technology. It depends on the complexity of it. It depends on how many different embodiments we're including in the application. And it depends on the entity itself, because the USPTO has filing fees that depend on if you're a large entity, a small entity, or a micro entity. So in general, I would say for a standard run-of-the-mill patent application, it's about $10,000 to prepare it and file it. Now, if you have one that's maybe a simpler, more streamlined or focused invention, then it might be $5,000 to $8,000. And then for more complex inventions or applications that include a lot of different embodiments, then it could be $15,000 to $20,000, and that's to prepare and file it. You know, on a monthly basis, I would say we work on applications in all of those ranges. So it really does just depend on the complexity of the technology.
If I could add in there, so when universities are considered to be small entities, so when we file a provisional, we're typically doing it with something we prepare in-house with our licensing managers. So our costs are $145 or $150. I haven't looked at the fees lately. So that's why we run like drunken sailors when we're filing provisionals, because it's costing us next to nothing. So that we do that when CMU owns the IP. When we don't own the IP, for example, undergraduates and master's students, many of whom maybe the situation people in the call are in, they can file by themselves a provisional, and the filing fee is just like $65. But you run the risk, as George pointed out, is like you have to do your homework and make sure that you're doing an enabling provisional. Otherwise, you haven't laid the foundation. You don't get that filing date for the full application. So if you do your homework, do it right, you can buy a year's time of provisional patent coverage, not coverage, but at least that filing date for like $65. And you can go out and tell the world, like, yes, I filed my provisional patent application. It's not a full application, but at least I had this filing date, and you got that for $65.
And
So I have a question for the panel. So a lot of the student entrepreneurs I work with have, great ideas, and they're thinking about filing for a patent. But to do a really thorough freedom to operate, it can be quite expensive. So what would you recommend to student entrepreneurs who have a good idea, but don't have, the money to spend on a thorough freedom to operate search?
I'd suggest do some poking around, see what they could find out on their own in terms of the prior art. But honestly, just file on it and let the patent office do their job and do the searching. But to kind of melt some of this stuff together, back to Reid's point and Loren's, our real goal with this dialogue today is to really be helpful to you. So we're trying to give you some really helpful practical advice. Um, One of the best pieces of advice I can give is that once the provisional is on file, you do the best you can. If you get a lawyer up front, that's great. If you can't, then you can't. You just file what you can file. But when it comes to the non-provisional, the inventors working with the lawyers always produce the better application. And entrepreneurs, they want to, they're energetic people. They want to get out and do stuff, and they want to spend time talking to boring people like us. But it's so important. We can do a great job on applications. It is always better with the inventor. The inventors understand the technology and what's on their minds more than we can guess. So I'm just really encouraging everyone who goes through the process to work hand in hand with whatever lawyer you may have, to spend a little time, hours, not dozens of hours, hours with your lawyer, really going through the invention, meeting with them to explain the invention so they can capture it, they can put it in the patent application, and you've got a better disclosure that's going to be throughout the life of the patent.
And just to echo
Another-
George's
Go
point there about you can do your own patent searches. You should do your own patent searching so you can understand what's novel. So that if you are writing your own provisional, you're writing the things that describe what's novel, not just like I have this grand idea. You want to narrow down into what's novel, and you can only do that if you know what else is out there. So at CMU in our engineering library, there's a reference librarian who will help people here do patent searching. And I think we're going to cover some of that later here too.
Yep. So Loren's going to cover that a little bit.
One of the other questions has to do with the process itself. It's not a binary thing when you file a patent. You make certain claims. The patent office might accept some and reject others. And it's not a matter of just accepting that. You can appeal certain claims and go back. It's not like asking your mom and dad for allowance. Your mom says no and you go to your dad. It's kind of like that, I guess, but you can appeal. Can you kind of walk some of the students through that process if you really think you have, a valid claim?
Well, as Dawn says,
Question.
what's that?
We have a question?
Yeah, I'm sorry. I don't want to leave the subject of entities. May I ask a question real quick? So I was just curious about, so you mentioned the different types of entities, and obviously there's different costs associated with that. How do you know which, like, how do they impact the patent filing process and the cost and the different entity status? Like, how do you know which one to choose?
You don't choose it. There's a definition of it. So if you're an individual, you're a micro entity. If you're a university and some other parts of the definition, you're a small entity. If you're above a certain size of entity, you're a large entity. So you don't choose it. You just fit this definition or that definition.
A large entity is usually 500 employees.
The micro entity has a certain income cap, and also you can only be listed on so many patent applications. So if it's your 6th or 7th patent application, you wouldn't qualify as a micro entity. The fees are 50% reduced for small entities, and then half of that again for micro entities.
And these fees are USPTO, like filing fees and so on. They're not the legal fees. The legal fees are independent of how big you are.
No, that all makes sense. And the fees are they dependent on your income or household income? Do you know anything about that?
Well, just for the micro entity, there is if you're an individual, there's an income cap, and I think it's something like 3 times the median income last year or something. But it's all available, like Reid was saying, in the definition of a micro entity. These are the criteria you would need to meet.
Thank you.
Mhm.
So we have a question in chat that says, to what extent should a startup prioritize patent shielding as a key part of their IP strategy? And that's a great question. So let's pause there for a moment. And it really, here goes that answer. It depends. And I think it's worth everybody's reaction to this. you ought to have a strategy on how you're going to protect your IP, and whether, because some of them are contrary, right? Like patents are different than trade secrets and different than copyright, and they protect different things. And so the judgment you're going to have to make is whether you want to spend the money on a patent for whatever your protection you're going to get for it, against the cost associated with it. The downside to patent that we're discussing is that there's a disclosure. You have to disclose what you're going to patent. And so, for example, if people can work around it, that's a risk. So some people prefer to go trade secret route and not describe it, to disclose it, such as, Coca-Cola, et cetera. So, and we'll talk about the trade secrets. So that's that issue. I also think that it's, let me tell you the one I don't love. The one I don't love is when people say, I'm going to get a patent because VCs require it or investors require it. It's, and different people have different views on that subject. I think that what VCs want to know is what's your competitive edge and how you're going to beat the market and how you're going to beat your competitors. And a patent is one way to create that picket fence, but there are others. And so just having a patent isn't enough. It's okay. What's the value of that patent, and how much, what's the breadth of it, and how good are the claims, as George talked about, and how broad are the claims, and et cetera. So just saying I have a patent because it's going to attract investors, I'm not sure that really covers it. So the answer is, unfortunately, it depends. To file a patent is not the most expensive thing in the world. So it may be worth to do it. And as others have said here, filing a provisional patent is relatively modest. It gives you 12 months to figure it out. But at the end of the day, I'm not sure if just to file a patent to bring on investors, I'm not sure that's the right answer. This ought to be more thought out, a little more thoughtful than that.
Well, to support David's "it depends" answer, which I agree with. At Blue Tree and a lot of other angel groups, the valuation of a company is increased if you have patents. As a startup, patents are expensive. Also, let's say you're a startup and you actually get a patent. Patents are only as good as your ability to defend it. And so, you got to take that into consideration. Again, the main benefit of having a patent as an early stage is if you think you can grow your company quickly and be acquired by a large corporation in your space that has rows of attorneys like David that love to go after companies for patent infringement. So it does depend.
Yeah, and it depends on the as I say, the scope of that patent and the breadth of it and the value of what it is, right? I mean, if it's the value of the invention, if you will. So, I mean, as an example, the life sciences world, a patent is hugely valuable, right? There's some others where it's everything. It's the game. There's some others where maybe it's not as important. So it depends on the software companies, for a large part, many software companies don't use patents. So it depends on the nature of what you're doing.
George, could you go back to?
Oh, go ahead, Don.
Go ahead, Stephanie.
Oh, we've got Ellen, we've got a hand raised. Do you want to ask your question?
Yeah, sure. I wanted to know, you talked about publication and patents. So I wanted to know what the limitations of publications are prior to filing. And I have a specific question about, is it possible to share the results of an innovation, of the effectiveness of an innovation, like just statistics, like by using this innovation, we found these improvements, but not give details of what the innovation is. Is it possible to do that without violating the public release requirement for patent submission?
Great questions.
The U.S. Treats, that's a great question, Ellen. The U.S. treats public disclosure differently than many foreign countries. In the U.S., we have to kind of draw a bright line between stuff that the inventor discloses and stuff that third parties disclose. Stuff that third parties disclose is prior art to another's invention immediately. And it's, it can block novelty and it can be used in the obviousness calculation. That which the inventor does in the US, it is possible in the US for an inventor to disclose something publicly, put it on the internet, put it on the front page of the newspaper, and then you've got a year to file the application for that technology. But many foreign countries don't give you that year. So we try and very, very strongly encourage clients to file something before the publication occurs. Now, the question is that disclosure, Ellen, in your question, enabling to the claimed invention? If you're just disclosing results, probably not. So it's probably not really harmful to disclose results.
Thank you.
Don,
In a lot of business competitions, we encourage the entrepreneurs to talk about the what, not the how.
Yeah.
If it's helpful.
Thank you.
Don, did you want to go
That's
back to
good
your
advice,
question about the application process, just so we don't leave that hanging? As we mentioned, it's important to get a great application on file with the disclosure and the specification, the claims and drawings and all that. You file that, you literally wait until someone picks it up in examining core, and that could be a year or 2 years down the road. They'll then examine it against the prior art and often issue an office action saying your claims, they might have formal rejections, your drawings aren't good enough or something like that, or we didn't like the way the claims were written. But often they will say your patent is not novel because of this prior art, or it's not obvious because of this combination of prior art. You then have a chance to go back and argue with the examiner as to why your invention is novel and non-obvious, or to make change to the claims to refine them. You can't broaden them. You can narrow them to maybe get around the prior art and support the argument of differentiation between what you're claiming and what the prior art covers. They can come back to you again with the final office action, and you can respond to them again and or appeal from there. So as Dawn suggests, the application process is not a one and done. But if there's a back and forth, you want to win that back and forth.
So is it safe to say that if you have a good IP attorney, the chances of successful appeals will be higher than if you're trying to do it on your own?
There aren't many guarantees in life, Don, but that's one of them.
Okay, trying to help you guys out.
Appreciate that.
I can't do brain surgery, so I don't do that. I think I've tried
Thank you.
myself, but no, it's just a question of using a professional, and you have to have professionals that you trust, because you want to work with them. This is a collaboration yields a better result. Absolutely.
And just to build off what George was saying, it is an iterative process and you can amend the claims, but you can't add any new subject matter. And that's why we really emphasize the importance of that original disclosure in your provisional or your non-provisional, whichever route you go, because you can amend the claims, you can narrow them, you can change the scope, but only if it's encompassed by what's in your original disclosure. You can't add new matter. And that's why that disclosure is so important up front.
You may file a follow-on application adding subject matter. It's called a continuation in part application. But guess what? You're only entitled to the new filing date for the added material. So prior art can come in front of that. So it's again, it's so important to get the good disclosure up front. And usually we can find something patentable with a good disclosure.
And just to jump in on top of that, in terms of this back and forth process with the patent examiner, and it's probably obvious, but just make the point even more obvious, that's going to cost you money. So when Loren was talking before about the upfront filing costs, that's just put something on record with the patent office. When they come back and say all claims are rejected because it's obvious, and you start this back and forth battle, you may do that multiple times, and each time it's going to cost you like $3,000 to $5,000. And then when it's finally issued, you have to pay an issuance fee. And then later on, you pay a maintenance fee, and later on, you pay another maintenance fee. And if you're doing it in multiple countries, multiply times number of countries. So the pricing that Loren was mentioning earlier is just the initial like ante of the poker game. There's going to be more rounds of raising the bets as you go through the game.
Let's pivot unless somebody has other than this. We'll make sure we cover a couple of the others before we go into sort of a little searching. And let's differentiate patents from copyrights, and maybe spend a moment describing what copyrights are.
David, we have one more question in the chat.
Oh, that's fine. Yeah.
Okay. What materials should you prepare before you begin the filing process? What materials should you prepare before contacting an IP lawyer to make the most of their time?
That's a great question. And the candid answer is anything and everything you can prepare. The more descriptions, the more drawings, if you have a sense of the prior art, anything can be helpful. Either because it's supporting the disclosure or it's prior art, as Reid suggested, that you're going to want to get around and just deal with it up front. So the more the inventors can put together, again, it takes some time to do it, but it's really well spent, and it can make the time with the lawyer much more efficient, much more effective, and frankly, less costly. Great question,
Yeah, so in the tech transfer office, typically we start with a research manuscript. So the background section of like, what have others been working on? What have they done here? What are their results and methods and so on? So that's our usual starting point. But if you're not like PhD student faculty member that's writing a research paper, I suggest like when you do your patent search, look at other patents in your field and see how much detail is there. So to the extent that you have that level of information when you prepare your own provisional or when you're working with a patent attorney, that's going to help them have a better starting point. So look at other patents and understand that level of detail. Do some patent searching so you can clearly state what is the novelty of what you're doing compared to what else is out there.
Thank you. Ellen, you had a question on breadth of patents, so maybe you want to ask it.
Oh, yes. So I want to know, like, how broad can a patent be? So, for example, can you patent something like, I have a specific application for machine learning or deep learning, and can you patent just using deep learning in that application? Or can you only patent the specific use of your solution of the machine learning for that situation?
I think it really has to go with the solution itself. And software is a real tricky area. You can't patent software per se. You have to tie the methodology in the program to some kind of tangible result. So I think it's fair to say that you need to be able to describe the invention in a kind of step-by-step fashion that gets down to the core of it. How's it different? So just if you're doing machine learning differently, then yeah, that might be something patentable there. But if you're just using machine learning in general for a different result, perhaps not. It's kind of, unless that would be not obvious. I can't think of an example off the top of my head.
So this is like really, I think I'm wondering if it's changed over the years, because years and years ago, like I worked with in nuclear power, and I actually worked for Westinghouse, and then I went to talk to GE, and GE said to me, oh, we're not going to use 3D modeling of nuclear power because Westinghouse has the patent on that, and we are waiting for it to run out. I thought, that's crazy. How can they patent something so broad? And then years later, a patent attorney said to me that you can't patent the idea. You can only patent the specific like technique that's used. You couldn't patent something that broad. So that's why I just wanted to ask you, because I've heard different things from different places.
I can't understand offhand how you can get a patent on simply the concept of using 3D modeling in nuclear
Yeah,
reactor.
I couldn't understand that
applications.
either. Yeah.
Yeah, it would probably be, it's this specific method of doing 3D modeling.
And
And
some,
somebody else
Then
could
you
come
put
up
that
with
map-
10
some
different
nuance.
ways of doing the 3D modeling. And they
Yep.
patented one method of doing 3D modeling.
So with an idea and software implementation of it, you have to have the specific implementation in order to attain a patent.
And tangible output, yes. And that goes back to David's earlier point about sometimes it's better to keep things as a trade secret.
So maybe
And-
that's a good pivot to trade secret.
If we,
George, yeah.
if I could say something before we go on
Yeah.
about software in particular, when you're thinking about going back to the earlier question about strategy, like how important is it for getting a patent? In software especially, you have to think about like, what's the longevity of the benefit of your novelty? It's going to take you 2 to 3 years to get a patent issued. Is the field going to have already moved on where there's 10 new methods that are better than yours, and you spent all that money to get a patent that's already been superseded by something new?
Great.
Yeah.
Thank
It's-
you.
I think it is just kind of put a ribbon around another aspect of this. As David said, you really want your roadmap, and that's why it's important, I think, to talk to a qualified intellectual property attorney to help you develop your roadmap. I agree, it shouldn't be driven by what you perceive the investment banking community to be. I think it's better people that develop their own roadmap, think about things, and what's the best way to protect them. And we go through that. We'd like to on every case. I think Microsoft was probably pretty smart to patent the Windows concept, but not all software is that fundamental. So it really needs to be analyzed on a case by case basis and
So what does
make
it mean?
decisions.
What's it mean to trademark it on, rely on trade secret?
So, can you repeat that, Dave?
What does it mean to rely on trade secret?
That's a great question too. Let's talk back even to a definition of what is a trade secret. A trade secret is anything that is kept secret and can give a commercial advantage. That is fundamental, but it has to be kept secret. And if you're asserting that you have a trade secret in something, and you're ever called upon to prove that in court, you're going to have to show how you kept it secret, how you maybe kept it under lock and key, how you provided or limited access to that, how you had only access by people under contract. You're going to have to prove what the secret is, how you kept it secret. And if you do, it's protectable as long as it is secret. It does not protect against independent development. Someone can have the same idea and go out and do the same thing, unless they're breaching a contract with you. So it's just so important to think about trade. Main message we got for you today, guys, is think about intellectual property. Just think about it, and then you could think more about what is it, what's the best way to protect it, but don't not think about it.
Why would one rely on trade secret rather than patent it? Let's say you could retain a patent and you decide, no, I'm going to rely on trade secret.
I think software is a good example of that. I think you can't patent software per se, but we can find a way to get around that and get patents that effectively cover software. But by doing that, you're going to disclose your maybe silver bullet that you may not want that to be disclosed. Trade secrets can have indefinite life until they're not secret anymore. They have a definite life. The classic example is the recipe to Coca-Cola. No one still knows what that is, and it has tremendous value still because they keep it very secret. They can prove the steps that they take to keep it secret, and it still has tremendous value. So think broadly for a second about what can be trade secrets. They can be economic terms of arrangements, software, configurations of systems, methods of doing business, customer data, supplier data, user data. That stuff always should be looked at as trade secret material.
Another domain where it's very relevant, it's like in the chemistry field.
Yep.
Where you might have, spent years figuring out like the temperatures and the timing and so on to control some process. And if you publish that in a patent application, the rest of the world's going to be able to do that themselves. And you won't necessarily know that they're doing it unless you go inspect their chemical plant. So in that case, it may make sense. We're not going to get a patent on this because we know how to turn all these dials, and we figure nobody else is going to figure it out, or we're going to have a lead on them so they can try to figure it out, but we're going to own the market by then.
So George, you mentioned, you have to prove that it is in fact a trade secret. So I have my secret sauce locked in a lockbox somewhere. The people actually making the secret sauce, the standard NDAs cover that, or is there something above and beyond a traditional non-disclosure?
I think, I'm not sure what you mean by standard NDA, but you want something that covers that specific secret.
But let me make a comment there. Standard NDAs, Don, to your point, have you'll get them, and they will always have a termination date, and they'll say that you can disclose this after 2 years, 5 years, whatever is negotiated. And if you're trying to maintain trade secrets, essential that you have an exclusion to that for trade secrets, because lots of people just sign them, say, oh, it's a standard NDA, and they've agreed to keep it secret for under for 3-5 years. Well, what that means is after 3 to 5 years, you've now allowed them to disclose your trade secret. So I always, and this is a fight that we have often on behalf of our startups and other companies, that you got to have an exception. They got to, as long as they keep it, they got to keep it confidential if it's a trade secret.
So many NDAs say term of this agreement is 3 years or 2 years.
Yeah.
Then what happens? You're free to use it and disclose it unfettered.
Right. Right.
To me, that's just untenable. You've got to provide. What I always say, because I'm very protectionistic, as you might be able to tell, I always say to our opposing counsel, you're not going to be free to use this in 3 to 5 years. It just the mere passage of time isn't going to vitiate the value in our trade secret. So you have to provide for it explicitly, though.
Yep. Cool. All right, so that's trade secret, and let's spend a moment on copyright. So because people have a choice. And so what's the deal with the copyright? What are you protecting in copyright that's different than a patent?
The big thing is the copyright protects the expression of ideas, but not the ideas themselves. So as we've been referring to the claims of the patent, the elements of the claims can protect ideas in combination. But copyright does protect ideas. It really protects against copying. The classic putting it on a Xerox machine and making a copy. That's in today's society. I mean, it's the internet. It's much easier to make copies and things and send them around. But it really protects just the copy, the physical copy itself. It will manifest the work itself is what's protected, not the underlying ideas.
So they can be independently created, and it's only the expression versus the idea, and it can be independently created. Whereas patent, presumably, even if it's independently created, you're still protected.
The test of copyright infringement is substantial similarity and access. So if you happen to come up with something that's somewhat different without reference to the underlying work, it should not be infringement.
Mm-hmm.
So but copyright protects, you certainly want to put a copyright notice embedded in your software code. And if someone copies the code, they would infringe. But if someone independently come up with the ideas in your code, then that wouldn't be copyright infringement.
And just we'll get to the question and thing, but the process to copyright, presumably you don't have to go to the copyright. You don't have to go through a patent like the patent application process.
Well, you should always put a copyright notice on things. Copyright, number one, exists upon creation, fixation, and tangible medium of expression, writing it down, storing in your computer. Those are fixation. It's good to put a notice on anything, a copyright notice on stuff that's going to be published. That alerts the public of your claim of copyright and eliminates the innocent infringer defense. You can go the step beyond in registering in a copyright office, which is more of really a registration process. It's not a grant like a patent. It's just a registration. If they see something that looks like a work, copyrightable work, and you give them the right information, they'll say, okay, here's your copyright number. It's important to register things because you can't bring a lawsuit for copyright infringement without a registration.
Hey, we have a question from Elena who asked.
Click on this one for a second, David. On
Oh yeah,
the
please.
copyright.
Yeah, okay. Yep.
Yeah, so at CMU, you might imagine we have lots of software inventions. And if it's like a conceptual kind of thing where nobody's ever done it, it's not obvious, and we think it has longevity to it, we'll file a patent. But we do more licenses each year of copyrighted only protected code than we do for patented technology. So just because it's copyright doesn't mean it doesn't have commercial value. And if we're licensing to a company, they're making the business decision. Like, we can read this research paper that's published from CMU and like hire our own software engineers to recreate the code, or we could just license this code that's already been written by these smart people at CMU and take it as is. They've already developed it. They've already tested it. It's just easier for us to like take that license and pay CMU than to pay engineers to recreate it. But that's a business decision. They could have just as easily decided, no, we're going to write our own based on that research paper.
And a lot of that basis is trade secret. You probably haven't registered the copyrights in those, right?
No.
You're providing them a secret code and letting them use that code.
Yes. But sometimes, we will have both copyright and patent protection on software. And when we do our license to an existing company or a startup company, provisions in our license will talk about copyright. Other provisions in a license might talk about patent. Depending on the situation, we take out the copyright license or we take out the patent language. So we change our license based on, is it copyright IP? Is it patent IP? Is it both that we're licensing?
Hey, we have a couple questions in chat, which are kind of good. I want to go through those a little bit. One says, could you discuss the strategy for protection of know-how? So it's interesting because we really don't use the word know-how, but it's out there a lot. Loren, George, Reid?
Know-how is trade secret. It's funny, I think the statutes generally, there's trade secret laws in various states and they use the word trade secrets. And I don't really know if they use know-how as much, but consider know-how as a trade secret, protected as such.
It's one type of a trade secret.
Yeah. And then we have another question that says, as IP lawyers, so that takes me out. Do you help individuals decide what's best for their idea or should your client know what they need to protect their IP?
I think we really want to help people make that decision.
Yeah, I mean, I think it's an iterative process where we tease out and collaboratively what's protectable and what's not. I mean, we spend a lot of time with our clients. I'll take this one, figuring out what is it that's protectable, because they wouldn't know, but we don't know what their IP is, what the technology is. So when these folks are talking about a collaborative process, that actually is the core of the collaborative process, trying to figure out what it is that's protectable, and then what's the best way to protect it. That really is, and that's very collaborative.
If you're within the university, it's university-owned IP, you're going to be working with the technology transfer office in your university on that strategy, and then at an appropriate point, get additional assistance from outside patent counsel if you're going in the patenting direction.
As long as we're talking about, let's spend a moment on trademarks, because that's also a huge value. And I could tell war stories on this one, but where we.
If I could, David, before you,
Yeah, please.
before you switch gears, I just want to,
Yeah.
piggyback on something Reid said. If your technology is through government-funded lab or something like that at Pitt or CMU, the universities are going to put a claim on that IP, and there'll be some type of royalty due to the university. That's the bad news. The good news is that the universities in both cases will help you with the filing costs of the patents. If you're a student at either university and you come up with an invention outside of a government-funded research project, it's your IP. That's the good news. The bad news is you've got to fund the filing costs for patents. Did I get that right, Reid?
Yes.
Okay. So there are some advantages of having university claimed IP, but it's really to do with the filing costs, which, as Reid said earlier, can be substantial if there's several iterations. Sorry, David, I didn't mean to.
No, that's good. Yeah, I appreciate it. Yep. Trademarks, service marks.
Trademarks are kind of a different animal. They reflect your brand of something, whether it's your services or your goods. So trademarks are defined as any word, name, symbol, or device that serve a source identifying function. It just distinguishes your goods from the goods of other people. Trademarks or an aspect, trademarks such as word marks. Just do it for Nike, trademark, obviously. Trademarks can be a design. They can be McDonald's arches. They can be a combination of words and design. McDonald's in the arch, that's a service mark. They can be colors. If the color is non-functional, it can serve as a trademark. So for example, pink is a color for Owens Corning's trademark for fiberglass insulation. I didn't know this before, but insulation doesn't have to be pink. It's not made naturally pink. They add that color so that when you see pink insulation, it's Owens Corning, and other people can't do that. NBC's chimes are a service mark for their television broadcasting services. So the main functions of trademarks are to identify and distinguish the goods of one person from those of another. They serve an important function because they guarantee a consistent level of quality. Whether you're getting a McDonald's in Market Square or in Beijing, you expect that level of quality. The McDonald's Corporation has set for themselves, but the consumer public knows what to expect there. It really represents the goodwill of the company.
Thank you.
I'll just throw out something funny there that Harley Davidson's engine sound is trademarked.
It's funny. Hey, Loren, do you want to talk a bit about searching?
Sure. I can give maybe a little general overview, and if people have specific questions, maybe raise your hand or put them in the chat and we can go from there. I think the two types of searching that come up most often for startups are the patentability searches and then the freedom to operate searching. So patentability search is a search you would conduct before filing a patent application. And in that case, you're looking for prior art. So George indicated that in order to obtain a patent, it has to be new and non-obvious over the prior art. Prior art, oftentimes we have, especially with people that are just getting their feet wet with patents, don't appreciate that patent prior art can be anywhere in the world. So even if you are just interested in obtaining a US patent, prior art that existed anywhere in the world can preclude you from obtaining that patent. And so it's really important to do a comprehensive search if you have the time and the means to see what is out there. And that is what a patentability search would be. There is no obligation in the US to do a patentability search. So you don't have to to search before you file an application. However, you do have an obligation to disclose the prior art that you find that's material to the patent office if you file an application. So that's kind of patentability searching at a high level. You're looking for prior art anywhere in the world that's publicly available. And that includes things like printed patent applications that maybe didn't ever evolve into a patent, issued patents. It also includes journal articles, websites. I've had YouTube videos cited by patent examiners as prior art. So it really does mean anything that's out there anywhere in the world. And then the freedom to operate search is you're looking for something narrower. In that case, you want to know if the product or the service that you would like to offer is going to be infringing somebody else's patent. So in that case, you'd be looking at US patents. If you're concerned about a US freedom to operate search, you're looking at US patents that are unexpired and still in force. So patents generally have a 20-year term. And as we've discussed, you have to pay maintenance fees during the life of the patent to keep them in force. So you're looking at in-force patents and looking at the claims of those patents. Oftentimes, you might see broader disclosure in the general description of the application, but we're looking at what the scope of the invention is as defined by the claims. So that's sort of a high level of patentability versus freedom to operate. And I'd be happy to answer any questions or, if people have more questions about that.
And people can go on the website, the PTO website, and do the searches themselves, right? It's pretty straightforward.
Absolutely. I mean, the USPTO.gov has great search tools, so you can use that to search for issued patents and published patent applications. You can also use Google Patents. There's a lot, there's a lot of different search engines, and it's usually helpful to think about all the different ways that your invention could be described. Think about different keywords, different synonyms, and then try to find the class and subclass that your invention would belong in. Look through those and see what the closest prior art is. And you might identify reoccurring inventors. You can search by inventor name. You can search by assignee name, the owner of the IP, and try to find the closest prior art. It is to your advantage to find that close prior art, because it can also help. Not only do you know when you're filing your application if you can get a patent, but it helps you to craft your claims so that you're really focusing on the point of novelty, and it can make that patent process and the back and forth with the patent office a quicker and a less painful process.
There's a question in chat as to whether you should simply search the USPTO database, or should you also search non-US databases as well?
If you're doing a patentability search, I wouldn't limit it to just the US, because as I mentioned, the prior art can be anywhere in the world. But it is a good place to start because there's a lot of prior art in the US alone. So, we usually do start with the USPTO patents and publications, and then would expand the search to look at worldwide patents using maybe eSpace, or go to Google and see what you can find online.
It's important to recognize that not just patents and patent applications are prior art. I mean, any printed publication, anything you can find online, for example, could be prior art, or in research databases or libraries.
So there's a question that says, does using the term prior art or FTO make the report somewhat admission if the patent later becomes challenged?
Well, we are careful about using the term prior art. If we're not sure that it's prior art, I mean, it isn't, you want to make sure that it is something that in fact existed before your invention. So I would be careful, for example, in the patent application to identify this is prior art, this is not. And freedom to operate. I'm not sure, I'm not sure what reports that would be a concern in. No.
Yeah.
Snow,
Let me
do you
make,
wanna-
good. George.
Snow, do you want to
Oh, sorry.
express your concern about this? Because we've had it come up with some students doing searches and how they refer to the searches and whether they're, they're using the correct terminology in terms of prior art or FTO, and whether the students may be characterizing it in a way that they don't want to be characterizing it.
Well, it's important if you're asking someone to do a search for you to know what kind of search you're asking for, whether it's prior art search or freedom to operate. But as Loren said, we don't say this is prior art in the patent application.
Mhm.
There might be references that we're going to disclose to the patent office, and this is important to recognize. Anyone associated with the patent application process, the inventor, the lawyer, anyone in that team is under an obligation to disclose prior art of which they're aware. It's not optional.
Mhm.
Have prior art, you have to disclose it if it might be material to the patentability of the invention. So what you find, you're going to have to disclose if it's relevant.
So I guess the really question is the term of freedom to operation was used everywhere. Sometimes I understand that if you are launching a new product line, a company wanted to know what is already there, if this product line will facing any challenge or have any infringement risk. That is obviously a good case to do what's the freedom to operate report. But at the beginning, as a startup company, would you suggest, and where do you see the benefit for a startup company to this kind of a report, and what's the better way of like doing differently from a established company with a product line launching? Is there a different, like a better way for a startup company to do this kind of research?
It all depends on the resources available. Honestly, it's a very practical question you're asking. If you have, big companies have resources and they can do searches as to what patents they might be infringing by practicing what they want to do. By the way, you can do trademark searching too, a separate issue. And they can invest those resources, but a lot of startups simply can't do that. So we're back to our friends, the inventors, suggesting that they poke around online and see what they can find in the PTO and maybe other search engines and seeing what's out there. And if it looks close, talk to a patent lawyer about it. And you really need professional judgment here. It's like me reading my own X-ray again. You need some judgment as to what might be relevant or not, and just inventors. We've been dealing with inventors for decades, and it's their baby, it's their brainchild, and sometimes it's good to get a kind of another viewpoint on things, so you can just have clarity in your decision making.
And just to emphasize, there are two reasons: one offense and one defense, right? And it's important to search to ensure that it's one thing to talk about your roadmap to figure out how you're going to protect your IP. That's one part. But the other part that we sort of touched on and make clear is that we don't want to be infringing on somebody else's patent. It is not funny to develop a product or a business plan that then is based upon in large part a patent, or a group of patents that are already issued. And you have to pivot around that, or you find yourself infringing on somebody's patent. So, regardless of whether you're going to patent or not, doing the kind of whether it be throttle freedom to operate or your own freedom to operate, or just going through the patent and doing the search, I think is a very useful exercise and an important exercise. I mean, we all have our war stories, and I have a war story of a client that got pretty far along and found that, and a potential investor, round one didn't, that their operations infringed somebody's patent. And the good news is they could work around it pretty, relatively inexpensively, but it did cause them quite a bit of consternation at the last minute. So it's not just about the patent, whether you obtain a patent, which is important. It's also making sure you're not infringing somebody else's patent. That's really important.
I see two more questions in the chat. The first is going back to software licensing for open source software licensed under licenses like MIT or GPL. Does that mean they're fair use for other companies to use for commercialization? I think the fair use is more of a copyright term, but what's your how do you sort of reconcile the software licensing and the open source? And I think this is Ram or Ram. If you want to ask the question yourself, feel free.
Yeah, so for like open source licensing, does that mean like if it's only under an open source license, does that mean anybody can just use it for whatever reason?
I think there's still some limitations in there. I don't think we can give a clear green light here, Ron. We really need to understand the terms under the open source license.
Right. It depends on the license, right?
So I'll say this comes up in our work, both sort of incoming and outgoing. So when we get an invention disclosure, one of the things we ask is, did you use any software that was covered by an open source license? If so, which open source license was it? Because sometimes it's a copy left kind of open source license, meaning anything that was developed with it also has to be open source and free to anybody. So we dive down into the actual language of which open source license covers the software that you used. Is it essential in your technology? Can you pull it out of there? Can you rewrite it? Can you work around it? How does that fit into what you're doing? And then on business strategy on the outgoing side, sometimes you want to release code or parts of your code through open source to build up a user community, but then you want others of it to not be open sourced and proprietary so that you can build your business around it. So it's something to strategize about and know about on both the front end and the back end, like how are you developing it and how are you releasing it? And there are many different options of types of open source licenses, and you choose the ones that match up with your strategy.
Thank you.
Brought it up front.
Yep. And here's a question that will make all the lawyers on the line. What is the fee for an initial consultation for your firm?
Well, I just did one today for free.
All right.
Normally that's the answer.
Well, that's about as good as you can get. I'm not going to even comment on that one.
I'll say that at CMU, if you do a search, if you can find it on the website, great for you, but an easier way is do a search for Schwartz Center for Entrepreneurship and domain experts. And we have like 150 people there in all kinds of domains, FDA, regulatory, accounting, strategy, marketing, and intellectual property attorneys. And all of those domain experts will say, I'll give you a half hour of free time if you're affiliated with CMU.
All right.
What about Pitt?
Good, what?
I asked what about Pitt?
Yeah, if you check with Rhonda, and Dawn knows this as well, there are plenty of subject EIRs at Pitt who will also offer you the opportunity for a free consultation. Dawn, do you want to weigh in on that?
Well, I've had to raise my consulting fees because of inflation. It used to be a small Starbucks, and now I'm up to a Venti. But no, there's a lot of resources at Pitt for business strategy, for intellectual property. There's a lot of resources. So I'd encourage anyone on this call from Pitt to check out the Big Idea Center website. the Innovation Institute website, the IEE website. There's just a lot of resources. So.
And I will encourage you, I mean, all of these lawyers on the line have done, wonderful free consultations for me in the past when I've sent students their way. So when these people say they're generous with their time, they really are.
Thank you. Well, I want to take one moment because we only have a couple minutes left, and we just make sure we've touched on ownership of IP, because I do think that we glossed over that, and it's really important that the startups own the intellectual. We talked about patents, we've talked about copyrights, we talked about trade secrets, we talked about strategies, but it starts with the core concept of making sure that the startup actually owns the intellectual property. So that means making sure that your inventor, that your founders didn't actually assign it to somebody else, have an invention assignment with somebody else. It's making sure that your employees and your founders have good, solid invention assignments in which they're assigning the inventions, what they're creating to the startup, and not just today, but in the future. That and every employee, key employee, or those who are providing services, actually have a current invention assignment. When I'm representing clients who are either obtaining funding or being sold, that is a key part of the due diligence that the investors or buyers conduct, and it can really muck up a deal and interfere with your ability to raise capital or sell, or enforce the rights, if you don't actually own the intellectual property. So I just want to put a pitch in there for that piece of it. And you'll find it in your employment or consulting agreements. Make sure there's a good, solid invention assignment agreement. When you're forming your company, make sure your founders assign. Make sure if you get the university, obviously you're going to license the technology from the university, so you get in that way. But it's just going to make sure that you own the intellectual property. I don't know if any other lawyers want to or weigh in on that, but just absolutely touch on that.
Absolutely right.
Okay, with a minute left or so, any other questions or things you want to touch on?
I don't know if Arjun, if you're still on the line, do you have any additional questions about being a student and your IP and concerns you might have?
I guess my question would be if we were interested in eventually selling our product internationally, do we take additional steps to defend the IP on the international markets?
Yeah, I think it's important to think about foreign patent protection. If you're going down the patent route, it's important to think about what countries do you really care about. Where might the product, where might infringers be? Where might it be made or sold by others? It's just cost prohibitive to patent things, in tons and tons of countries. But if you're really kind of smart about it, you can file maybe a centralized application under what's called the Patent Cooperation Treaty, and then nationalize it in various countries later. It'll buy you some time, maybe 30 months or so, to make those decisions later. But it's really good to think about this stuff. Another overriding theme to everything we've been saying is think about this stuff up front, and you can set yourself up in much better position by thinking about these things and making some kind of minor steps, small steps up front, that if you have to do them later, it's going to cost you, many times more.
I'll just say at CMU, if we think there's going to be a business reason to protect outside the US, say it's like a semiconductor chip or something, and we want to protect it in Taiwan and Japan and so on, we will start the process by filing, as George said, this thing called a Patent Cooperation Treaty, or PCT application. And that functions loosely like a provisional in that it's a placeholder. It holds the date at the international level. And then later on, you need to nationalize that in individual countries. So CMU will file that international thing. But when we get to the point of nationalization, if we don't have a licensee ready to pay the bill, we will only nationalize in the US. Gotcha. So that creates this 30-month timeline from when we first filed the provisional till we're nationalizing. And if you're a startup, you have 30 months to get out and raise some money to spend on international patenting, because we're not going to.
I see. Great, thank you.
Alina, last question. Alina, you had a question? Had your hand
Actually,
up?
it's not a question. I really sincerely want to thank you guys for your time. I mean, it's, I know how expensive lawyer time can be. I know people laugh about it, but it means a lot that you guys took all of your time to talk about this, especially for some of us who are interested in continue these discussions, who might be really nervous and excited about their quote unquote babies. So thank you.
Well, thank you. Thank you for the comment. It's been an absolute pleasure. And you should feel free. There will be a couple PowerPoint presentations that are going to be put online. It's formal. They have a little bit more formalized presentation regarding this. So we'll get that online for you to take a look at if you want to use that as a resource.